Hello, my name is Alex Spyropoulos, and today I'll be talking about international law and online privacy, a major issue that affects all of us. Whether we realize it or not, our personal data is constantly being collected, stored, and sometimes even misused. But where do our rights stand in the digital world? I will also be discussing the TikTok ban and its role in the continued discussion in maintaining your online privacy. Privacy as a human right. So, first of all, I'd like to start by making something very clear. Privacy, including online privacy, is a fundamental human right. The United Nations recognizes this under Article 12 of the Universal Declaration of Human Rights, or the UDHR. This states that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. While Article 17 of the International Covenant on Civil and Political Rights uses very similar language to explain the right to privacy. In Canada, privacy is also protected under the Canadian Charter of Rights and Freedoms, Section 7 and 8. Section 7 states that everyone has the right to life, liberty, and security of the person, and the right not to be deprived therefore of, except in accordance with the principles of fundamental justice. Courts have used Section 7 to uphold privacy in cases involving government surveillance, access to personal information, and decisions related to bodily autonomy. While Section 8 states that everyone has the right to be secure against unreasonable search or seizure. Courts have ruled that this protection extends to digital privacy, meaning that police need a warrant to search cell phones, emails, and online communications in most cases. Protection of online privacy by the UN. In July of 2012, the Human Rights Council introduced the first ever UN resolution to affirm that human rights in the digital world must be protected and promoted to the same extent as human rights in the physical world. Since 2013, the United Nations General Assembly and the Human Rights Council have adopted numerous resolutions on the right to privacy in the digital age. One of the most recent resolutions was adopted in September of 2019 and emphasizes the need to prevent government surveillance and corporate misuse of data. Resolution 4215, and I quote, calls upon states to review their procedure, practices, and legislation regarding the surveillance of communications, their interception, and the collection of personal data, emphasizing that such activities must comply with international human rights obligations. Data protection and privacy legislation worldwide. Although the United Nations does not have specific international laws that countries must follow regarding online privacy, the UN plays a very important role in creating guidelines that countries should follow and encourages member nations to develop laws that protect individuals' online privacy. As of right now, according to the United Nations Trade and Development, 137 out of 194 countries have put in place legislation to secure the protection of data and privacy. More specifically, this is related to the collection, storage, use, and sharing of personal information to third parties without notice or consent of consumers. Therefore, countries create their own laws on online privacy, and from my research, it is clear that the gold standard is considered to be the GDPR, or the General Data Protection Regulation of the European Union, which came into effect May 25, 2018. This outlines strict rules about how companies can collect and use personal data. The GDPR applies to organizations located within the EU, as well as organizations located outside of the EU that offer goods or services to or monitor the behavior of the EU data subjects. Online privacy laws in Canada. The federal law that regulates online privacy in Canada is called the Personal Information and Electronic Documents Act, or PIPEDA. PIPEDA and the GDPR aim to safeguard individuals' privacy and personal data. There are, however, some significant differences between these laws and regulations. For example, the diagram below shows that while the GDPR covers all organizations, PIPEDA only covers private ones. Furthermore, PIPEDA does not allow individuals to delete data, and the fines for violations are much lower in Canada. To keep up with the ongoing changes to the online world, Pepito was updated in 2015 to better protect individuals, specifically when it comes to information regarding privacy breaches and fines for noncompliance. Individuals in Canada are also protected by the Privacy Act that relates mainly to information held by federal government and federal institutions. There are additional protective measures provided by provincial and territorial laws. So, despite all of these laws and efforts, there have been many breaches of people's personal information online. My first case highlights the recent data breach of TDSB Power School involving all of us or most of us. As explained in the TDSB letter sent home, the data breach has affected millions of current and former students and thousands of staff, leading to an investigation by the Federal Privacy Commissioner. Some examples of information that was impacted include health card numbers and home address. The second Canadian case involves Ticketmaster. In May of 2024, Ticketmaster experienced a major data breach exposing personal and payment details of millions of customers. The breach led to an investigation by Canada's Privacy Commissioner to assess the impact on affected users. Ticketmaster faced criticism for delaying customer notifications, raising concerns about transparency, and handling cybersecurity threats. So, I'm sure you all have heard about the temporary recent ban of TikTok in the United States. This controversial case in the United States brings to light another significant challenge when it comes to online privacy and security. That is, how can governments respect and protect individuals' online privacy rights while also protecting national security? TikTok has faced increased criticism due to concerns over national security, data privacy, and content manipulation. U.S. officials fear that ByteDance, TikTok's Chinese parent company, could be forced to share American user data with the Chinese government, posing a major security risk. In addition, there are concerns that TikTok's algorithm could be used to amplify or suppress content, potentially influencing public opinion or even elections. Lawmakers have also raised concerns over TikTok's extensive data collection practices, questioning how user information is stored, accessed, and potentially misused. While the ban was set to take effect, a 90-day extension was granted. Therefore, the ban may still come into effect if the sale of TikTok's U.S. operations does not take place. So, what crimes are the Chinese being accused of? The Chinese have been accused of serious violations related to data privacy, espionage, and cyber intrusions. In 2019, TikTok was fined for illegally collecting children's data without parental consent, violating U.S. privacy laws. Then, in 2022, TikTok admitted that ByteDance employees in China accessed the U.S. user data without authorization, raising concerns that the Chinese government could exploit this information. In 2023, cybersecurity reports linked Chinese hackers to cyber attacks on U.S. infrastructure, further fueling fears that TikTok data could be used for espionage. These accusations have led to global investigations, restrictions, and calls for stricter regulations on the platform. In general, the Chinese have been accused of state-sponsored hacking and surveillance and espionage. Proven occasions of spying/hacking online. It is usually difficult to prove incidents of online espionage, spying, and hacking, but in the cases below, there is considerable evidence of proven Chinese involvement. For example, in 2015, the U.S. Office of Personnel Management was hacked, dating back to November 2013. It exposed the personal and security clearance information of over 4 million employees. In August of 2017, the FBI arrested a Chinese national believed to be involved. When he arrived in the U.S., and in February 2020, the U.S. Department of Justice charged 4 members of the Chinese military with the 2017 attack on Equifax, an American credit bureau company, which was also linked to the OPM breach as part of the same larger operation. Therefore, the Equifax attack is another example of cyber Chinese espionage. The Center for Strategic and International Studies has published a survey on Chinese espionage in the United States since 2000, with numerous examples of proven cases of Chinese spying, hacking, and espionage. This is my bibliography and references. Thank you for your time. These are my discussion questions and readings. Thank you.